Right, the first one that I would like to look at in terms of parental responsibilities and rights, C.S.S. versus O.R. This hails from Pretoria on the 18th of January 2024 under the pen of Puku A.J. and the citation on SAFLI ZAGP PHC 37. And this matter, if you would like to follow along, and I promised the guys of the bundles I would say this earlier, and I apologize that I didn't. It is on page 48 of your case law bundle, and you can find it on page 1 of your summaries. Now, this was an interesting care and contact urgent application, and it was basically for a return of 2 minor children before the starting of the school term. So what had happened in C.S.S. versus O.R. is that the parties ended their relationship in 2020. The children initially stayed with the respondent and then moved over to the applicant due to financial difficulties. A dispute arose when the respondent simply removed the children and refused to return them. The applicant then quite correctly launched an urgent application for the return of the children. Now, this matter hails from urgent court, so obviously one of the chief issues addressed by the court is Rule 612 of the Uniform Rules, and what was focused on specifically is whether or not the applicant would have been able to get substantial redress at a later stage, and the court found obviously that the applicant would not find substantial redress. It looks at the best interest of the child. You'll see obviously in the next couple of judgments, every single one of them without fail cites Section 28.2 of the Constitutional paramount importance of the best interest of the child, as well as Section 7 of the Children's Act. And then finally, the court discusses the role of the family advocate and how critical their job is in investigating the best interests of children regarding residency, care, and contact. So what happened in this matter? The court put in interim arrangements to ensure that there is stability for the children. An order was made for the Office of the Family Advocate to investigate, and the parties were given leave to supplement their papers after receipt of the Family Advocate's report. And I'm quickly going to go through to the case law bundle, and I will share with you just the terms of the order itself. So let's go all the way up to page 50 odd. Let's have a look and just get our orders over here, and let's have a quick looky. I'm so sorry, folks, for the shameless scrolling. This matter, C.S.S. versus A.J. It is earlier on. I've gone to the next one. Here we go. Provisions of the Uniform Rules of Court relating to time and service. Okay, let me just pop myself on the side so you can see a bit better. Are disposed of. Office of the Family Advocate. Pending the Family Advocate, children be placed in the care of the respondent subject to applicant's rights of contact, which shall be exercised as follows. Pending, respondent shall not be entitled to remove the children from Gauteng. Both parties given leave to supplement their papers. Obviously, a lot of discussion in this judgment, as in all of these types of judgments, regarding the factual matrix of the matter, and it is worthwhile to go and give that a read. The court makes two quite interesting, in my view, quotes, which I've highlighted for you, and they are as follows. The first one, paragraph 31. I will try and do my best to get the font up a little bit, but unfortunately sharing on this platform, it doesn't allow me to zoom as nicely as I would have liked, but I'll try the next time to just make it a little bit bigger. Paragraph 31 is very interesting in terms of the court adopting a child-centered approach and telling the parties off a little bit. The provisional measures are made not for the benefit of the parties, but only for the best interests of the two minor children. When parties are no longer together for one reason or another, they should try as far as possible not to use children to fight their battles. And absolutely ain't that the truth. Then paragraph 32, the court goes on and says, consequently, this court as upper guardian will grant a remedy that puts the best interest of the two minor children at the forefront. Their well-being and safety are what matters at the moment. Then just as a notable aside, paragraph 25, it's not up on your slide, the court just reiterates that the Constitution and the Children's Act are also clear that the rights of children must always be considered as a matter of priority. I found it interesting using the term a matter of priority in every matter involving children. So that is C.S.S. versus O.R. all the way from Pretoria under the hand of Puku A.J. on 18 January 2024.